And Vicky, do we have another call on the line?
Yes, I do. I have Susan on the line. She had a relative that was hit by a pickup truck.
All right. Thank you, Vicky. Let's talk to Susan. Susan, this is Roger Reed Miller of Lawyer on the Line. How can I help you?
Well, about 2 or 3 months ago, my grandson was riding his bike. He was riding it on the right side of the street, and in his own lane, close to the curb, and a man came out of nowhere in a pickup, a big pickup, and he turned wide, and he struck my grandson on his bike, and it broke his leg 3 places above the knee on the left leg, and he ended up having to go to the hospital and get steel plates put in.
Right.
One attorney that my family talked to said something about that it was partially my grandson's fault.
Well, how old was your grandson?
He was 7.
All right. So what is your question for me?
Well, the grandson also said that the man was on a telephone.
Wow.
Is there anything that can be done with this, and how would we go about doing it?
Well, was there a police report made of the accident?
Yes. Because
About
the ambulance came and picked him up, and
how long ago was the accident? I'm sorry.
I think it was like 2 or 3 months ago.
Okay, 2 to 3 months ago. And your son, I take it he's had, or grandson, excuse me, he's had experience riding a bike. It's not the first time he's...
Oh, yes. Uh-huh.
Huh. And it was in his neighborhood?
Uh-huh. And it was on his side of the road for riding, and the man just kind of pulled out and made a wide turn.
Well, okay, Susan, generally speaking, the laws in the state of Kansas and the Supreme Court decisions interpreting those laws say that if you are under the age of 7, comparative fault cannot be assigned to you. If you're 7 or 7 to 14, some comparative fault might be able to be assigned to you, but it depends upon the maturity and so forth. And when I say you, I mean to your grandson. Based upon what has been told, or what you're telling me, and that apparently has been told to you by your son and other folks, it doesn't sound like there was significant fault on your grandson's part, and especially if the driver was on a cell phone. Now, we could probably prove that to some degree of certainty, whether or not the driver was on the cell phone. The difficulty may be in establishing the precise time of day that this collision occurred. If you can establish that, then you can obtain this gentleman's cell phone records from the cell phone company. Now, the time is of the essence because these cell phone companies don't keep these records forever, but they do have a record of when he was on the phone for this particular period of time. There is a record of that, and that needs to be requested right away. And if in fact he was on the cell phone at the time of the accident, then clearly he had a divided attention, is what I would call it, and he would have significant fault in contributing or leading to this accident. And I would say that he would have far more fault than your grandson, unless your grandson made some maneuver that we're not aware of. Now, are you aware, were there any witnesses to the accident?
There were some children, because they were, this place has children all over the place, and people know, that children are out there, and there's no sign saying to be slow for children, but the people know that they are out there, and they are.
So there may be a witness. Is that what you said? Okay. Well, again, 2 months is not too long, but we're starting to get long in the tooth with respect to some memories, okay? So the sooner that witnesses are talked to, their recorded statements are taken, the better chance it is that you will be able to know, your grandson and son will be able to know, and mother and father will be able to know just exactly what happened and what they will be able to prove or not prove with respect to this claim. I don't really know why the attorneys turned your son and grandson down. Based just upon these facts, I would say that it's a pretty good case. Okay?
Okay.
Thank you, Susan. I appreciate the question, a very interesting legal question. Whenever you get involved in an accident and you believe that the other driver was at fault and you believe that that other driver was on his or her cell phone, number one, you need to report it to the police, and number two, you need to take whatever means possible to establish that that person was on the cell phone. Because once you establish that, that will go a long ways towards proving that this person's attention was divided and it was not properly on you or your vehicle, and that that person more likely than not contributed or caused the accident because of their inattention, if that were the facts of the case. So you need to take whatever steps necessary to get a copy of that individual's cell phone records.